If it may please the court, I'm Dan Cloberdance. I represent Jeffrey and Julie Waring, who are the appellants in this action. As you know, they are the borrowers in this case, and the subject is a home equity loan, a $400,000 home equity loan that was at one time secured as a junior second position lien on the Warings' personal residence. It was secured until the time that Northern Trust foreclosed on its own first position loan, which was a prior construction loan for about $1.2 million, about 1.1 was the balance, which extinguished the second position loan. The facts here are not in dispute. The record below is there's not any contested facts with relation to the lien positions. In fact, in Northern Trust complaint, they admit that their foreclosure on their first lien extinguished the second lien prior to the time the lawsuit was filed.
I'm sorry, say that again?
Yes. In Northern Trust's complaint, they state and admit that the foreclosure trustee sale of their first position lien extinguished their second position lien, and therefore they were suing directly on the note. As you can gather from the briefs we filed, we have two entirely different arguments. One is relating to the anti-deficiency statutes. It's a technical argument, and I'm certainly going to talk about that. The other one is kind of a more of a general argument with related legal theories of mitigation or actual payment of damages and unjust enrichment. They tie in together based on the basic fact that here it is not contested, and the record before this court is uncontested. I want to throw that in, that the value of the home at the time of foreclosure was worth more than both liens. On the record below, we presented the appraisal, the bank's own appraisal, around the same time as the foreclosure, showing the property was valued at over $1.7 million. That's more than both loans combined. The bank did not introduce any evidence, didn't attempt to introduce any evidence to controvert that fact. We also have the declaration of Jeffrey Waring stating he believed the property was worth more than both liens. But most importantly is the bank's...
Then.
Excuse me?
Why didn't he just sell it? Why did he default?
It was the market, Your Honor. It was a 2010, that time period going into 2011.
But whatever the market was, if it was worth more than the value of the loans, why not sell it and keep the profit? He was trying
to sell it. Just he wasn't able to sell it. He waited they waited too long, perhaps, to sell it. As most homeowners are overly optimistic about the value. Perhaps he tried to sell it for too high of a price at one time. But at that time, the values were falling, but the homes weren't selling at all, the luxury home market in this time period. It picked up soon after 2010, 2011. These homes started selling again, but it was very difficult to sell a home back then. And certainly in hindsight, he wished he had, or he wished he had filed bankruptcy and bought some more time, and he would have been out of this mess completely, presumably based on hindsight. With respect to the anti-deficiency law, had a very odd thing happen in this case, much to my dismay. Judge Foster originally ruled in our favor on the anti-deficiency law, saying that it applied, the action would be barred, and it's based on the exact legal analysis that we're arguing here in front of this Court of Appeals. Judge Gerlach was then assigned the case. Don't know why Judge Foster didn't keep the case, but Judge Gerlach looks at the same issue and says, no, I'm not going to find that the anti-deficiency statute applies here, and relied on the Ludi case, which the bank relies on, which, as I argued in my brief, Ludi is the exact opposite facts of what we have here. Ludi involved two mortgages, not two deeds of trust. Keep in mind, Ludi is a 1979 decision. Arizona didn't adopt the deed of trust statutes until 1971. So in 1972, a lot of lenders were still using mortgages. And the only way you can foreclose a mortgage is through a judicial foreclosure. Now, that's a very, very important distinction, because the argument for the anti-deficiency argument that applies here is based on, let's go back to Baker versus Gardner. The original ruling of Baker versus Gardner states quite clearly, anytime the property falls within the type of property that the anti-deficiency statute applies, the personal liability of that borrower is abolished. And they use the word abolished. You cannot sue on the loan if the anti-deficiency statutes apply. Here, the anti-deficiency statutes apply. Single-family residence actually lived in by the borrowers and located less than 2.5 acres. So there's no dispute that the anti-deficiency statutes would otherwise apply. Then we get into the difficult part to comprehend is the supplemental opinion that Justice Feldman wrote 3 months later in Baker versus Gardner. So the original ruling is all personal liability is abolished. If that was the only opinion, we wouldn't be here today. There would be no lawsuit possible. But then we have the supplemental opinion, which was urged by the banking industry, and the Supreme Court makes an exception. And the exception is, hey, if you could treat your deed of trust like a mortgage and do a judicial foreclosure, we're going to apply the mortgage anti-deficiency statute to any creditor who can treat its deed of trust like a mortgage, hypothetically. And going back to the original anti-deficiency laws enacted in 1971, for whatever reason, the legislature made the mortgage anti-deficiency statute more narrow. It only applies to purchase money loans. And this is not a purchase money loan. It's a home equity loan. We concede that. Perhaps the reason was because there's redemption rights and other protections given to the borrower. But the deed of trust anti-deficiency statute only applies to, well, it applies to all loans. So if the bank had done a trustee sale on a non-purchase money loan, it would be barred by the anti-deficiency laws, whether it's purchase money or not. The deed of trust anti-deficiency statute is broader, more favorable to the lender that we have here. So what the court did, the Supreme Court in the Baker supplemental opinion said, we're going to allow deeds of trust holders who can treat their deed of trust like a mortgage to be able to elect to sue on the note because they could hypothetically do a judicial foreclosure and seek a deficiency after treating that deed of trust like a mortgage and doing a judicial foreclosure. That's the holding of Baker. So if you look at the exception that's created, you have to have a situation where you have a lender who can treat its deed of trust like a mortgage, because otherwise
Counsel,
you don't get into the fiction.
A little bit confused. So I'm looking at the supplemental opinion, but you have to actually choose the judicial foreclosure procedure for that exception to apply, right? No?
I would think so, but no, because what the court says, if you can do it, if you have the ability to treat your deed of trust like a mortgage, you can sue directly on the loan. I wish it did say that, Your Honor, because we would win this case quite easily if you had to do a judicial foreclosure. But what the court says is, if you can, when you have that option available to you to treat that deed of trust like a mortgage, now we're going to apply the mortgage anti-deficiency statute, which is more restrictive to the borrower, and it has to be a purchase money loan to be protected.
I'm not seeing that in the supplemental opinion. I'm looking at it. It says, where, however, the creditor chooses judicial foreclosure, he can obtain a deficiency judgment in all cases. It goes on from there. By choosing judicial foreclosure, the creditor can obtain a deficiency judgment. I thought you had to actually choose it.
Well,
I don't know. I'm just asking.
If you did, this would be an easy case, and I'd win, just based on that language alone. But I don't think. But I'm going to be real candid with the court. I don't think that's a fair reading of the case. I think it's more, especially based upon opinions from this court since Baker versus Gardner, is you don't actually have to choose a judicial foreclosure. You can sue on the note if you can treat your deed of trust like a mortgage. And there's some other opinions since then that say that from this court. I wish you were right, Your Honor, but I can't in good faith make that argument because I don't think that's a fair reading of the case.
So you don't think the language in the supplemental opinion, and I'll just read it, if that creditor chooses to proceed by judicial foreclosure under 814D, the governance statute prohibits election to sue on the note only in cases involving purchase money collateral. You don't think that really encapsulates the rule here?
I think it does to some extent, but the court is saying is if that remedy is available to you, because what the supplemental opinion is saying is that you have the right to elect to waive your security and sue on the loan. And if you sue directly on the loan, you're not doing a judicial foreclosure, because a judicial foreclosure involves it's a different process than suing directly on the loan.
But if you do a judicial, as I read this, if you do a judicial foreclosure on the first, take the facts of this case,
Okay.
on the first, then because the second was not a purchase money loan, you have the right to elect to sue on the note, even though the security is extinguished. Is that not your reading?
That's not my reading, because and also this case was not a judicial foreclosure on the first.
No, it wasn't. In fact,
I wish if it had been.
That's what I'm saying. I think the rule says, had it been, then a judicial foreclosure on the first, then I think you would clearly lose. And I acknowledge that it wasn't. I'm just asking if that's your...
I think the court's talking about what you do on the second, not what you do on the first. Because in Baker versus Gardner, the lender on the first and the lender on the second were different. It was separate. This was not a situation where the lender held both of the loans.
Well, that's an interesting read, though, because would the statute or this language in the supplemental opinion ever come into effect if it applied to the second? If the first is foreclosed either by a judicial or non-judicial means, the second security interest is gone, isn't it?
Absolutely, it's gone.
So you couldn't exercise judicial foreclosure of the second security interest, which is why I thought they must be talking about the first.
No, they're talking about they're talking about the second, and I agree with you entirely. You can't, if you extinguish the second through a senior liens foreclosure, you can no longer treat that deed of trust like a mortgage. And in the Needham versus Crawford case, which I cite in my reply brief, a big block quote, Judge Fidel for this court writes that an extinguished junior lien holder who's extinguished by a senior trustee sale can't sue on the loan because the anti-deficiency statutes still apply even though your lien has been wiped out. So Needham versus Crawford is, even though it was a purchase money loan, right on point as far as extinguished lien holder cannot sue on the loan if you're extinguished. And that's what, and as Judge Foster found in this case, agreeing with me, he said this anti-deficiency statutes always apply even if you're extinguished, and now you can't treat your deed of trust like a mortgage because you intentionally and consciously extinguish your own lien by your own senior lien holder's foreclosure, by wiping yourself out. You can't fit under the hypothetical situation required in order to sue on the loan. Keep it in mind, let's go back to the original opinion, Baker, you can't sue ever when the anti-deficiency statutes laws apply. Now we're creating an exception, and in this fiction that's created by the Supreme Court says when you can treat that deed of trust like a mortgage, which you always could if you weren't extinguished, presumably, we're going to apply the mortgage anti-deficiency statute, which means you do have the right to sue if it's a non-purchase money loan. But if you can't treat that deed of trust like a mortgage, it's the situation we have here with Northern Trust Bank, you're stuck with the original anti-deficiency statute that applies to deeds of trust, which applies to purchase money and non-purchase money loans.
I understand your argument properly. Because there was no judicial foreclosure proceeding invoked in this case, we can pretty much forget about the supplemental opinion.
No, not because the supplement.
Am I misunderstanding?
Okay, the supplement. The only reason that the bank has any right to sue to begin with, in light of the anti-deficiency statutes applying to this property, is because of the supplemental opinion. The supplemental opinion gives Northern Trust the right to sue in the first place. Let's say that the foreclosure on the first never occurred. They had a right. They would have a right to waive their security and sue on the loan under the supplemental opinion.
Sure.
Under the original opinion of Baker, they would not. The supplemental opinion allows them to sue directly on the loan.
The facts of this case. Yeah. What fact in this case triggers the supplemental opinion?
The supplemental opinion depends which way you look at it, Your Honor. The facts of this case is because you have a non-purchase money deed of trust. Supplemental opinion applies to first liens, second liens, third liens, whatever lien position it may be. It just says when you have a non-purchase money loan, secured by a deed of trust, and you can treat that deed of trust like a mortgage.
Only
you
if
can
you
sue.
do choose to proceed by judicial foreclosure?
Well, if that's the case, Your Honor, then summary judgment for the appellants, because they didn't do that in this case, and they couldn't do that in this case. They didn't proceed with a judicial foreclosure on their second
Well, and
lien.
that's why I'm trying to understand if that's your argument, because it seems to me that the right to sue under the supplemental opinion is conditioned upon the election to proceed by judicial foreclosure, and that election wasn't made here.
That's correct. Although I would, in all candor to the court, I would say if you could do it hypothetically, I read that you would be allowed to sue. But the hypothetical doesn't exist in this particular case either. Your Honor, I just also want to urge you to look at Mid-Kansas and the unjustment enrichment rule. I think that applies here. We've got a situation that if you fair reading of the Supreme Court's reading in Mid-Kansas is when you have a lender who takes back property, has two liens on the same property, and ends up with a piece of property worth more than both loans, that's unjust enrichment to allow the lender to sue directly on the loan.
Sorry, I didn't catch that.
Okay, I'm sorry. The Mid-Kansas case, which is after the Baker versus Gardner case, and another Justice Feldman opinion, states that when you have two loans, a lender has two loans against the same property, and forecloses on one of those loans, it's unjust enrichment to allow that lender to sue on the other loan if the property value exceeds both loans. That's Mid-Kansas. Now, it's the flip side, because in Mid-Kansas, the lender foreclosed on the second and then sued on the first. We're here, the lender's suing on the second, foreclosed on the first. But the same principles of unjust enrichment apply, and I would urge this court to look at that as well. I'd like to reserve the remaining time I have for rebuttal, if I could.
Yes, of course.
Okay, thank you.
Burgess?
Thank you, Your Honors. Todd Burgess, Gallagher & Kennedy, on behalf of the Northern Trust Company, the appellee. The issue in this case really is which of the two Supreme Court decisions apply. You have Baker versus Gardner, on which the court has been discussing, and then you also have Southwest Savings and Loan versus Luty. The answer to that question lies in the fact that in this case, the Northern Trust equity credit line that is at issue was a non-purchase money loan. And so you can slot the case into one of the two categories based on that fact. In Baker versus Gardner, the first position loan was a purchase money loan, and the second position loan was a carryback, also purchase money loan. In Luty, you had a purchase money first, and you had a non-purchase money second.
But they were mortgages.
They were mortgages. But the fact that they were mortgages makes absolutely no difference under the Baker decision. In the court's discussion, I'm sorry.
Let me give you then the same question I gave Mr. Cloverdance. It seems to me that the choice, not the theoretical possibility of treating a deed of trust like a mortgage, but the actual choice to treat a deed of trust like a mortgage is essential to the right to sue under the supplemental opinion. Do you disagree with that?
I do disagree with that, Your Honor. And the first point I would make in that regard is the original opinion, the supplemental opinion didn't carve out an exception to the original opinion. The original opinion said,
well, if the original opinion applies, you have a tough argument.
Let's go to the language. The last part of the original opinion, if the court looks at page, it's the second to last paragraph. In reaching this conclusion, we do no violence to the text of the statutes, nor do we leave ARS 33722 a meaningless shell. That's the statute that says that you can elect a remedy. You can elect to waive and sue on the note. The creditor beneficiary can still elect to sue on the note in all cases except those involving the particular mortgages and deeds of trust described in the anti-deficiency statutes. See Southwest Savings and Loan Association versus Luty. When Justice Feldman went back and did the supplemental opinion, because you had all these amicus briefs coming in and say, wait a minute, we need clarification here, Judge. Are you really saying that if you have a non-purchase money second and you get foreclosed out, you can't sue on your note? And so Well, Judge Feldman went back and he gave the summary and application, and there's 3 sentences there that are important. And I think the one that's most important for this argument, Your Honor, is the 3rd sentence. The 3rd sentence of the summary and application says, therefore, where the creditor can obtain a deficiency judgment, he can also elect to waive the security under ARS 33-722 and sue on the note.
But here, on the facts of this case, Northern Trust couldn't elect to waive the security because it had already extinguished the security.
But
That's not waiving it.
Northern Trust waived its security simply by allowing its security interest to be extinguished. And there's a case that was decided in this court in May of 2016 that addressed that exact issue. It's the Compass Bank versus Bennett decision. Mm-hmm. And in that case, the issue was Bank of America had a first lien against the property. Compass Bank had a junior deed of trust. After B of A noticed the trustee sale, but before the sale was completed, Compass Bank filed a complaint on its non-purchase money second. The borrower then complained that Compass shouldn't be allowed to sue on its non-purchase money second because it never affirmatively and expressly waived its security before it filed the lawsuit. The court disagreed, and the court said that by doing nothing and allowing its junior deed of trust to be extinguished, Compass effectively waived its security. Interesting, in that case, the borrower, who was represented by Mr. Kloberdans, argued or conceded to the Court of Appeals that if Compass had waited until after the sale had actually occurred and its junior deed of trust had been extinguished, then there would be no issue with respect to the waiver. And that's exactly what Northern Trust did in this case. It waited to sue until after its deed of trust was extinguished. Now, the Compass Bank versus Bennett decision is 240 Arizona 58. It came out in May of this year, and it's a Division I decision. But that's exactly, that holding of the case is exactly on point, and it really obviates this argument about whether or not there had to be some affirmative act by Northern Trust before it could sue on its deed of trust. And in that case, the Court of Appeals said, if you had waited, Compass, if you had waited until the trustee sale had occurred, the very fact that you allowed it to be extinguished is all you need to do to waive. And that's what Northern Trust did here. So I think that decision is very important. I think it confirms that Northern Trust has the right to sue on this second. And the court also, in that Compass Bank versus Bennett decision, they just discussed an earlier decision, Wells Fargo Credit Corporation versus Tolliver, 183 Arizona 343. That was discussed in the Compass Bank versus Bennett decision. And in that case, it's the same issue, basically. Tolliver held a foreclosure of a senior lien and extinguished. Tolliver held that the foreclosure of a senior lien extinguishes the junior lien by operation of law. And in that case,
Councilman, I'll have to take a look at the case, but was that dealing with property that's subject to the anti-deficiency statute? Was that residential property that was 2.5 acres or less? In
Tolliver or Compass Bank, Your Honor?
Compass Bank.
Compass Bank was an anti-deficiency property, I believe.
Okay.
But Tolliver had the same type of an issue, and Tolliver held that if you foreclose the senior lien and you extinguish the junior lien by operation of law, the court is not going to interpret 12-1566 to require the unnecessary act of waiving a junior lien that's already been extinguished. It's basically saying if you have a junior position, you get foreclosed out, you don't have to go and record something that says I'm affirmatively waiving my lien because your lien is gone. And so I think based on those two cases, the distinction that Mr. Kloberdans is trying to make for the appellants just doesn't exist. There is no requirement under the supplemental opinion in Baker versus Gardner that says you have to do some affirmative act or make some election. It merely says, and if you look at the last sentence of the summary and application at 160 Arizona 107, therefore, where the creditor can obtain a deficiency judgment, he can also elect to waive the security under ARS 33-722 and sue on the note. And that's exactly what Northern Trust did here. It sued on the note after it was extinguished. The other case that I'd like to address, which was a case that counsel mentioned and was cited in the reply, is the Nydam case. Appellants claim that the Nydam case stands for the proposition that a junior lien holder whose lien is extinguished no longer can go and sue on the note. Well, one, that's directly opposite to the holding in Ludi. Ludi stands for the proposition, and it was not overturned by Baker, a fact that's been acknowledged by the Supreme Court and various courts of appeal. Ludi says a foreclosed out junior lien holder with a non-purchase money second has the ability to go and sue on the note. It's not a deficiency action. It's an independent action on that note. The Needham case, the difference between the Needham case and this case is in Needham, like in Baker versus Gardner, both loans were purchase money loans. You had a first position purchase money loan and a second position purchase money loan. Well, in that case, of course you can't sue on the second, because Baker versus Gardner is very clear that if you have a purchase money loan, it doesn't matter whether you hold a trustee sale or don't hold a trustee sale. If you get foreclosed out and you hold a purchase money loan, that's it. You have no recourse. And the reason for that, and in Needham it cites to it, when talking about the Baker decision, the court specifically cites the Supreme Court's reasoning in Baker of protecting homeowners from the financial disaster of losing their homes to foreclosure, plus all their other non-exempt property on execution of a judgment for the balance of the purchase price. And that's the key, for the balance of the purchase price. That's why the second lien holder in Needham couldn't go after its loan, because it was a purchase money loan. That's not the case here. We have a non-purchase money second. The other issue, counsel raised the Mid-Kansas case for the proposition that Northern Trust action on the second, it should be precluded under the doctrine of unjust enrichment because it foreclosed the senior lien and then is trying to sue on the junior lien. The Mid-Kansas case is not an unjust enrichment case, and the facts of Mid-Kansas were exactly the opposite of this case. In Mid-Kansas, you had a lender that had held junior liens and senior liens. They foreclosed the junior liens and took the property subject to the senior liens. And when they bid and obtained the property, they reduced their credit bid by the amount of the senior liens because they knew they were taking subject to those liens. In this case, and there's a good reason why bettors would do that, right? Because if you're a junior lien holder, you take title to the property subject to the senior liens, you know that although you might not have personal responsibility for those liens, you're going to have to pay those liens off if you want to keep the property, because the senior lender can just come and foreclose you out. In the opposite situation, where you have a lender who forecloses the senior loan and takes title of the property, you're not taking subject to any liens, you're not reducing your credit bid because all the junior liens are extinguished. So the doctrine of merger and extinguishment doesn't apply. Mid-Kansas.
Let me just ask you,
I'm sorry.
though, to come back to Compass for a moment.
Sure.
There was a concession in Compass that the anti-deficiency statute simply didn't apply, and I'm not seeing the basis for that concession.
I think the concession was based on the fact that it was a non-purchase money loan, Your Honor.
Okay, but then doesn't that...
And that's why the anti-deficiency statute doesn't apply in this case as well. It's not. This isn't an anti-deficiency case, because once our junior lien gets extinguished and we have a non-purchase money loan, anti-deficiency doesn't come into play anymore. That's what Ludi says, is that once you have a junior position non-purchase money loan, if you get extinguished, that's no longer an action related to a deed of trust. It's not a deficiency action. It's just a breach of contract on an unsecured promissory note at that point, because your security is gone.
So then you would read the holding in the original opinion of Baker as having essentially no effect at this point.
No, the original holding in Baker was that if you have a purchase money second, first or second, and you are given a deed of trust as security for that first or second, your sole recourse will always be only to the property. You can never waive your security and sue on the note.
Well, the original holding of Baker was that the legislator's objective was to abolish the personal liability of those who give trust deeds on qualifying property. Would you say that that language still has any force and effect?
It does, because that language is directed at purchase money loans. That the whole legislative history here and the whole policy is to protect homeowners who go out, buy a home, give deeds of trust for that, and then they are then they get foreclosed out, and then a lender comes back and sues for a deficiency for the purchase to collect the balance of the purchase price.
That's a very rational position you're taking, but I don't see it reflected in this language in the original opinion in Baker.
Well, I think maybe, Your
Perhaps
Honor,
it
frankly,
should have been.
maybe it should have been, and I think, frankly, Your Honor, that's probably why there were so many amicus briefs filed and why people wanted some clarification of, Supreme Court, what exactly are you saying to us here? Are you saying that we can never go and sue and collect on a non-purchase money second? And that's why the Supreme Court came back. They issued the supplemental opinion, and they provided a very easy roadmap under submarine application to try to sort this out for people. And I think the key really to that submarine application is that last sentence. And that's the situation we have here today. Northern Trust had a non-purchase money second, and therefore it had the ability under 33-722 to waive its security and sue on the note. That's true whether it would have done that before or after its lien was extinguished. If they would have sued before the trustee sale had occurred, it would have been the Compass Bank decision, right? In that case, the Compass sued before the trustee sale was completed, and the court said, that's fine. You don't have to wait to have your lien extinguished.
So
there's nothing affirmative that you have to do.
So what your construction of Baker would be in that first sentence of the supplemental opinion, the summary and application section, where it says, where the creditor chooses non-judicial foreclosure, he cannot obtain a deficiency judgment if the collateral is within the class protected by the deed of trust and anti-deficiency statute. You would read into that purchase money loans. That's the class?
Right.
Is that what you are arguing?
Well, see, the thing, Baker versus Garden, if you have, say you have a first position senior deed of trust, and it's a non-purchase money first. So you have someone goes out, they have unencumbered collateral, they go to a bank and they get $1 million non-purchase money first, secured by a deed of trust. Under Baker versus Gardner, if they conduct a trustee sale and they only recover part of the balance of the loan, the anti-deficiency statute says because you held that trustee sale, you cannot get a deficiency. If you want to get a deficiency in that circumstance with your first, you have to elect judicial foreclosure, and then the court will enter a judgment for the balance due on the loan, will give the sheriff an order that says go out and sell the property, and then the proceeds are applied against the loan, and you still have a judgment for the deficiency.
Or non-purchase money first.
For a non-purchase money.
The problem, though, is if you read the sentence that way, as Judge Gould hypothesized, that makes the following sentence surplusage, right? I mean, the following sentence deals with the distinction between purchase money and non-purchase money and says that distinction is only relevant where the creditor chooses judicial foreclosure. So the first sentence of summary and application seems to be written in an intentionally absolute way.
Right, and you're right. Where the creditor chooses non-judicial foreclosure, and that's what I was trying to say. If you choose non-judicial foreclosure, in other words, if you have a deed of trust and you elect to foreclose it non-judicially, it doesn't matter whether it's purchase money or non-purchase money, you can't get a deficiency if the collateral is the type of property that fits within the anti-deficiency statute. Less than 2.5 acres residence used for dwelling. So if it's the type of property that fits within the statute and you have a deed of trust and you elect non-judicial foreclosure, you can never get a deficiency. That's the first sentence. Right. That's what I meant to say. I apologize if I didn't explain it correctly.
But that seems to say that you cannot get a deficiency within, it says if the collateral is within the class protected by the deed of trust anti-deficiency statute. And in this case, the second is a deed of trust. And even though it's non-purchase money, it is within the class that's protected by the deed of trust anti-deficiency statute. So I guess I'm not seeing how you are able to sue on the note, because this seems to be, if you choose judicial foreclosure on a deed of trust, on a class protected by by a deed of trust anti-deficiency statute, which includes purchase money and non-purchase money, then you you cannot obtain a deficiency. That's how I read that sentence.
The first sentence, but I think you have to read it in connection with the next two sentences.
Well,
because
I
the next two sentences, I'm sorry, Your Honor.
I haven't. I still don't.
So the next sentence, where, however, the creditor chooses judicial foreclosure, he can obtain a deficiency judgment in all cases except those involving purchase money loans on the type of real property that the mortgage foreclosure statutes describe.
But that's
And
talking
then
about mortgage
the ability
foreclosures.
The ability to waive security and sue on the note is tied in the third sentence to the ability to obtain a deficiency judgment. So if you haven't elected judicial foreclosure, it doesn't seem to me that you have the rights available under the second and third sentences.
Well, the third sentence says, therefore, where the creditor can obtain a deficiency judgment. It doesn't say that you have to elect judicial foreclosure. It says, where the creditor can obtain a deficiency judgment, he can also elect to waive the security and sue.
Right, but the definition of that where is in the preceding sentence, isn't it? The second sentence that says you've got to elect judicial foreclosure to get the deficiency judgment.
Your Honor, I respectfully, I disagree. I think the third sentence is saying, the first sentence basically is saying you have a deed of trust, you foreclose non-judicially, you never get a deficiency. The second sentence says if you have a deed of trust and you choose judicial foreclosure, then you could get a deficiency judgment. The third sentence says if you have the type of loan where you could foreclose judicially, then you have a third option, which is just to waive your security and sue on the note. Those are the three sentences, three different choices, right? And I think you have to read those three sentences separately. The third choice is just if you have the type of loan where you could do a judicial foreclosure, then you have the ability under Baker versus Garden to waive the security and sue on the note, which is what Northern Trust did here.
That's
and that's consistent with the recent decisions. Compass Bank versus Bennett is on all fours with this. They basically say you don't have to have an affirmative and express waiver. You can allow your deed of trust to be extinguished, and then you can still sue.
well, the waiver is a little bit of a different question, though, than the election of remedies.
Well, but to elect a remedy, that's what you have to do, right? If you're gonna sue on your note.
Well, let's back up.
There has to be some waiver.
The election I was talking about is between judicial and non-judicial foreclosure.
But there's a third option, Your Honor, and that's to waive your security and sue on the note. You always look in the commercial context that's where 33-722 comes into play most often. If you have a loan that's secured by a deed of trust, there's nothing in the law, and this goes to the mitigation argument somewhat, where counsel says you have a duty to mitigate a promissory note. Well, that's not true. If you have a commercial loan that's secured by a deed of trust, you don't have to go out and foreclose your collateral. You can waive your security and you can just sue on the note.
Hold on a second.
I
Do you have some follow-up questions?
No,
or-
I'm-
All right. Thank you, counsel.
Thank you, Your Honors. Appreciate the time.
Mr. Cloverdance?
Thank you. Wish to point out about the Compass Bank versus Bennett case that counsel cited. I was co-counsel in that case. I'm very much aware of it. In that situation, very different than this case. There, the bank sued before the trustee sale was held by the senior lender. So they had the right to elect to treat its deed of trust like a mortgage at the time it filed a lawsuit. Had the facts been these facts, we certainly would have been making the same argument in that case. So it's very important to note in the Compass Bank, when you read that case, that there the bank actually filed its lawsuit. The court made its determination to elect its remedy before its lien was extinguished. So it did have a right.
They still had a security interest to waive.
They did at the time it filed a lawsuit.
But then didn't Division I just hold that doing nothing and letting the security interest get extinguished is the same as waiver?
Is an election.
So does it matter when they sue?
Well, in that case, we couldn't even make the argument we're making now in that case because they did have a right when they filed the lawsuit to do a judicial foreclosure, and they were wiped out by they didn't extinguish themselves like Compass Bank did. Like Northern Trust Bank did here.
So you're suggesting that any statement concerning lawsuits brought after extinguishment would be dictum?
Dicta and actually wrong. Legally, I would say so. Absolutely, and that's a very important factual distinction. Also, I do agree that this may come down to do you apply Ludi or do you apply Baker versus Gardner? Baker versus Gardner obviously comes afterwards, and if there's inconsistent, that should be the holding. I don't think the cases are inconsistent because in Ludi, 1979 case, the court dealt with a non-purchase money mortgage in second position. So the court says the anti-deficiency statutes never apply to this particular loan because it's a mortgage that only is protected with purchase money loans. Here we have a deed of trust that's non-purchase money that is protected under the deed of trust anti-deficiency statute. So it's apples and oranges. It's a huge distinction because Ludi deals with a situation where the subject loan was never protected by the anti-deficiency laws because it was a non-purchase money mortgage. Had that been a deed of trust, it would have been a very different case. Here, if Northern Trust had a mortgage, the Ludi case would apply. But here, the anti-deficiency statutes do apply. In the Needham versus Crawford case, Judge Fidel says in conclusion, here, as in Baker, for the second position deed holder to execute on her note after the first position deed holder extinguished the property owner's equity would be inconsistent with the patent legislative objective of the anti-deficiency laws. So in Needham, Judge Fidel, writing for the opinion, says, look, even if you're extinguished, if your deed of trust is extinguished, the anti-deficiency statutes still apply. And that's exactly the situation we have here. And looking at the Baker opinion, you're exactly right. You have to read that paragraph together. You can't, in the court saying the only reason that a deed of trust holder can sue on a non-purchase money loan is because you can choose to do a judicial foreclosure. And if you don't have that choice or actually make that election one way or the other, either case, the lawsuit directly on the debt is barred.
Is that dictum? I mean, how much of the supplemental opinion was actually even necessary to resolving the case in Baker?
Honestly, you could make the argument it's all dicta, but it's certainly when you have a
make that argument.
I would not make that argument. Well, if I made that argument, we win. So either it's dicta, in which case it doesn't apply, we win, the borrowers win, or you apply it and interpret it as it's written, and that is you have to be able to do a judicial foreclosure to sue, and the borrower wins in either case. Where it's dicta or not, if it's dicta, it'd be better for me, but I don't think it's fair reading as dicta, honestly.
All right, thank you, counsel.
Thank you very much.
Counsel will issue a written decision in due course. Thank you. We're in recess.